SJC-12204. Brian Benoit v. City of Boston.
Mr. Becker, good morning. May it please the court, John Becker representing Brian Benoit, plaintiff appellant in this action. The case involves the appeals of two Superior Court decisions in which Mr. Benoit attempted to enforce the order of the Department of Industrial Accidents granting him workers' compensation. In both cases, the Superior Court relied on Chapter 268A, Section 25, which we'll call the suspension statute, to deny the benefits that he was ordered to receive by the Department of Industrial Accidents. Excuse me. We have in our brief a number of issues regarding waiver and jurisdiction. We do believe that you don't need to get to the merits, that the Superior Court judge should not have considered the 268A 25 argument, that it should have been raised before the DIA. DIA should have had an opportunity to address this issue, and more important—
What were they going to say? What was the DIA going to say about that? That's, as the city says, that's totally outside of its jurisdiction. What were they supposed to do with that?
Well, I disagree, Your Honor. I think what the Chapter 152 says is that if an insurer, in this case a shelf insurer, has an objection, a reason why the person should not be getting benefits, then they need to bring it before the DIA for the DIA's first look at it. And in this case, they did not do that. They should have done it. And in that case, we would have been in the normal course of procedure. It would have been appealed to the—
So would the DIA have the authority to apply the statute?
Yes, Your Honor.
To this case? Has that ever been done?
I don't have a specific instance of where it's been done, but they certainly have a right to look at the statute and say, well, this looks like a disqualifier, and this is a disqualification of getting benefits. If they decide that Chapter 25's reference to compensation includes workers' compensation, then they get to look at it. It would be it's an unusual set of circumstances, but this would really be the best agency to decide.
Interpret Section 25? What compensation means in Section 25? Why would they be the best agency?
Well, because they're determining not necessarily what compensation means, but whether workers' compensation fits within the meaning of compensation in Section 25.
That's what compensation means within 25.
Well, they don't need to look at other things, whether it includes unemployment compensation or sick leave benefits, but they need to. They're the best situated to determine that.
Don't they have a jurisdiction that is whether you have a work-related injury? Isn't that their scope of what they do?
My understanding is the scope of what they do is to determine whether somebody is entitled to benefits under Section 152. And this Section 268A, Section 25, is in the nature of a defense to that.
Does this, I don't remember exactly what it is, but does the chapter lay out the kinds of, does it specify some of the reasons that one might not be entitled to workers' comp?
Yes, there are things like causation and
not.
It doesn't list. No, it doesn't list the statute. And I want to take. I don't want to take a lot of time on this issue, just because I recognize that the framing of the amicus brief question indicates to me that the court wants to get to the merits.
Can I just ask you a question
yes.
before you? The city first said no to the benefits, not having anything to do with that statute. Isn't that right? Back in 2012.
Yes,
they
Your Honor, and
terminated
that
the
goes to my argument on the merits. There are really three components of benefits that we're talking about here: before the suspension, during the suspension, and after the suspension. The before period, which is a period of 3 months from August 5th to November 8th, 2011, there is absolutely no basis in any statute, or even really in the Superior Court's decisions, to explain why Mr. Benoit did not receive benefits for that period.
This accident happened on September, wasn't it September 5th?
The injury was on September 5th, 2011. The city paid benefits until August 4th, 2011. Then they stopped.
You mean 12, you must mean 12, or something.
No, 2000.
12.
Right, 2012, I'm sorry. August 4th, 2012. And then from August 4th, 2012 until the suspension,
Which was
November 8th.
Okay.
There's a period, inexplicably, no payments. And then again, based on the city's position, somewhat inexplicably, they start paying again in January of 2013, and then they stop again in June 2013. The order of the court, of the DIA all along, was to pay from the time of the injury, September 5th, 2011, till the present. So
can I ask you on that
Yes.
point? Put aside whether the city did or didn't pay. If somebody is suspended and then resigns having been convicted of a felony, but there was, in effect at the time, a workers' comp order saying, you know, you get partial disability payments starting now and continuing. What happens to that when the person resigns?
they continue to receive benefits.
For the rest of their life?
Yes, well, till they either retire or the injury becomes, they're no longer injured. That's the unique thing about the workers' compensation statute is,
So if you were 23 when this happened, and you didn't retire till you were 65, the city of Boston is paying you and you've committed some horrendous felony, doesn't matter, you just keep on going for 40-something years?
Your Honor, there are other aspects of the statute that I don't have in my brief that would limit the amount of benefits that somebody could get over time. But if there was proof that the person was still injured, that it was a result of the employer, then yes. I mean, that's one of the things I think that makes this so different and why it's clear that the legislature wasn't really even considering workers' compensation when they wrote this statute. Because the workers' compensation, I'll just give you three hypothetical situations. One is the one that Justice Botsford just gave. Let's say that he's injured on September 5th, 2011, and resigns from his position on September 6th. He would still be entitled to benefits for the entire period, no matter what happened with his criminal situation. With one exception, with one important exception, which is if he was incarcerated under Section 8(2)J, he would no longer receive benefits. If he was a public employee and the employer, as you'll note, Section 268A, Chapter 268A, Section 25, is a permissive statute, not a mandatory statute. It is permissive for the employer to suspend the person. It's not mandatory. It says may be suspended. So let's say that the city of Boston, for whatever reason, decided not to suspend him at this time. He would have continued to receive benefits. Now let's look at a third hypothetical. What if he's working for a private ambulance company? There's no Section 225, and he's injured. In the same circumstances, he's convicted, or in this case, guilty plea. He would continue to receive benefits. So the idea that workers' compensation is compensation within the meaning.
You mean that the private chalk
Yes.
employs him, that even though they fire him, they must continue as long as the company exists to pay him workers' comp? That cannot be right.
Your Honor, the workers' compensation cases, and I've cited them in my brief, state specifically that termination of employment by resignation, termination, et cetera, is not a grounds for terminating workers' compensation benefits. Workers' compensation benefits are about the injury and the loss of earning capacity that comes from the injury. Now, one of the things that the reason that it's important to call Section 25 the suspension statute is because it only deals with the suspension period. There are other statutes out there that deal with what happens if somebody gets convicted. And in fact, you'll notice, I don't have it in my brief, but if you look at the Brissett and Reynolds cases that were decided in the 1960s, the language of the statute at that time, and those cases have to do with Chapter 30, Section 59, which is the state cognate provision. Those statutes at the time talked about what happens when the person is convicted. What happens, and they say they're no longer allowed to have their job. They eliminated that language from the statute in the 70s, so that the statute specifically refers only to the suspension period. So our position is workers' compensation is not compensation in the sense that unemployment benefits or sick leave benefits or wages, because it is something that you receive in return for waiving your right to sue the employer in tort. But even if you find that it is covered under the workers' compensation is compensation, you still haven't gotten to the issue of post-suspension benefits. The post-suspension issue, I think...
Post-termination.
Post anything. In this case, it was resignation. But it could be anything. There are other statutes, and I think the reason why, I can't speak for the legislature, obviously, but a rational reason why they would have taken out language about post-suspension issues from the statute when they revised it in the 1970s is that there are other statutes out there that deal with this situation. There's Chapter 4196 that says you can't be a police officer if you're convicted of a felony. There's the provision of, the pension laws. Chapter 32 has a number of provisions. You can't, if you're convicted of a law applicable to your position, if you're convicted of a law having to do with moral turpitude. The unemployment provisions, you don't get unemployment if you're fired for willful misconduct in violation of your employer's interest or knowingly violating a rule. The workers' compensation statute could have included those provisions, but they didn't. Instead, the only thing that stops you from getting workers' compensation, not getting fired, not resigning, not getting convicted, the only thing that prevents you from getting workers' compensation is being incarcerated. And Mr. Benoit was never incarcerated.
Now, if I can turn you, let's assume you're right. The amount of partial and total incapacity here rests in part on his salary as a paramedic.
That's correct, Your Honor. The way that the legislature has decided to determine benefits, and when I say benefits, they're really looking at the term future earning capacity is the term that gets used in the case law. You look at Sellers' case, 452 Mass 804. They look at, it's a very practical assessment. If you've been at the same job for a year, then they just look at what you made, divide it by 52. That's your average weekly wage. But there's a case where the person only worked for a couple of months. They were a seasonal employee. So what did they do there? They looked at other employees' wages. What did they make? There's also a case, Sellers' case, where they say if you have two jobs, you get to include both of those jobs. So what they're saying is that it's connected, but it's not connected. It's specifically independent in many ways of the employment relationship.
So even if you're right, would we not have to remand it to have it recalculated on something other than his salary as a paramedic?
No, Your Honor, because what the average weekly wage is very specific. It says you look at the past year, what did you make, and divide it by 52. If it's not, and the administrative law judge had no problem doing that. He came up with, I believe it was $800 a week for the
Right, but that's
partial.
because he didn't consider the suspension.
That's correct. He was looking at his salary, as he would have made it, but he was employed for and earning money for a period of the time that he was out. There was a 3-month period that he could look at, and he could also look at before that, before his injury. There's no need to look just at the.
So if I'm just did this math, if it's $800 a week, so he gets from the city, as far as you're concerned, for the rest of his life, $41,600?
I'm not willing to say for the rest of his life, Your Honor, because I believe there are other provisions in the Chapter 152 that may limit that, and I haven't researched that issue, but I don't know that for a fact. What I do know is that he is not cut off by the resignation, by the conviction, by the even if it was a termination, that wouldn't end his entitlement to benefits.
One last question. Did the city's claim that he wasn't actually injured ever get adjudicated before the DIA?
That was not an issue. The only issue that they brought up to the Board of Review had to do with the issue of whether he had rightfully invoked his right to not speak because of self-incrimination. There was no issue that was brought in their appeal of the ALJ's decision about whether he was injured or not. That was never really contested, as far as I know.
I thought that was part of the reason that the benefits were terminated to begin with. They contested causation and they contested all of
I
these
believe
things.
that they listed all of the possible reasons you could contest, but none of those things were found to be contested, found by the ALJ to be legitimate. And the ALJ conference order that came out in early 2013 was the one order they did actually abide by, the one from January to June 2013. So it's pretty clear, and then based on their appeal, that they weren't pushing that issue. If they had first thought that that was a possible issue, they weren't pushing it, and it certainly didn't get raised at any higher level.
So you're basically saying on the merits that this is a question of whether or not workers' compensation is compensation for the purposes of the other statute.
That's only one of my arguments, Your Honor. I have 3 components. The pre-suspension period, you don't even need to get there. Pre-suspension period, there's no question. There's no statutory basis whatsoever. The suspension period is the one that you're talking about, where the suspension law clearly says you can't have any salary or compensation during a suspension. And so the question then becomes, is workers' compensation compensation within the meaning of that term? And we believe it is not, for the reasons I described in my brief. But the third section is a very important section, which is after the suspension is over. The suspension statute says nothing about that. It doesn't talk about it at all. It's a gap.
The voluntary ending of a suspension so you can get money?
As long as it's not being done like in the Reynolds case, I'm sorry, in the Lettieri case, or the Kennedy case, in an attempt to sort of evade the imposition of the statute. The chief in the Lettieri case was trying to avoid the retirement pension aspects of the law. He wanted to retire, and so he resigned, and they said that wasn't a real retirement or real resignation. But our case is a real resignation. He resigned on the same day that he
Suppose he'd
pleaded
been
guilty.
terminated.
The same thing, yeah. It's
Matter if they'd fired him either.
if he was fired on the same day that instead of resigning, it would have been the same outcome. He would still be entitled to workers' compensation benefits for as long as the statute allows. And there's nothing about a termination that terminates workers' compensation benefits in and of itself. It's important to recognize that these issues are dealt with elsewhere in other statutes, the issues of what happens after the suspension is over. And in this case, if the legislature has left a gap in there, I think one of the, as I said earlier, one of the issues that I think the fact that they didn't provide for post-suspension benefits to me, indicates that they weren't thinking about workers' compensation. Because if they had, anybody who's practicing in workers' compensation knows that they exist after somebody gets convicted of a crime. It happens all the time. So that to me is additional proof that compensation doesn't mean workers' compensation. Thank you, Your Honors.
Morning, Chief Justice Gantz, members of the court. My name is David Sussick. With me is Tom Pagliarulo. We represent the city of Boston in this matter.
Can you explain why they didn't pay during the pre-suspension period?
Yes.
I'm talking about?
Yes. Because the language of Section 25 provides that as soon as notice of the suspension is given, it immediately suspends the employee from office and bars them from receiving any further compensation arising out of their employment. At that time, because the Department of Industrial Accidents order hadn't issued yet, it was issued in the future, and when it was issued, he was already under suspension.
But when was, doesn't the suspension get triggered by being indicted?
Yes, I'm sorry, Your Honor.
Was he indicted?
He was indicted on October 31st, 2012.
But didn't you stop paying before that?
So, no, let me briefly go through the workers' compensation history. So, when he claimed to first suffer his injury, he was not under indictment. That was September 5th, 2011. Okay. There was a period of time where the city paid without prejudice.
Right.
That went through August 4th, 2012.
Right.
Then it stopped. And then, so he wasn't receiving any workers' compensation.
Had you not been ordered to pay at that time?
I'm sorry?
You had not been ordered to pay at
No,
that time?
both. At that point, Mr. Benoit brought a claim for further benefits.
On August 5th or something like that?
Yeah, around that. I'm sorry, I don't have the
After
date.
you stopped paying?
Yes.
Okay. So you were
Or
paying
I'm sorry, he
voluntarily?
appealed the conference order. He was, no, that's right. He filed a claim. He filed a claim around that time.
But while it was, I thought you were paying because that's what you're supposed to do until pursuant to the conference order, no? I mean, you're doing it without prejudice, but wasn't there an order that you do that?
Yes, there was an order. That came, though, on,
Wasn't it before that?
he filed a claim for further benefits. So he was paid through August 4th, 2012.
But wasn't that pursuant to a conference order?
No, Your Honor, it wasn't. It was just paid without prejudice.
And then what happened that made the city stop paying in August of 2012?
Well, during a pay without prejudice period, the employer can anytime determine that it doesn't believe either that the original injury happened or that the person's no longer disabled and entitled to benefits.
And so that's what brought you guys
That's
to
what
the
happened.
DIA?
Yep.
Now, I'm going to read you a part of our opinion in ICAP versus Great Northern Insurance. I think it was last year. General Laws, Chapter 152, Section 26 provides that when an employee is injured in the course of his or her employment, that employee, quote, shall be paid compensation by the insurer or self-insurer. Therefore, under Massachusetts law, although the employer purchases the workers' compensation policy, a workers' compensation insurer is directly liable to an injured employee for the workers' compensation benefits provided by law. The insurer does not reimburse the employer for its payment of these benefits. Why are these payments not, if you had an insurance company, it would be the insurance company paying, correct?
That's true, but the issue of liability, Your Honor, that's the question, is whether Section 25 disqualified Mr. Benoit from receiving benefits during the
But we're
time
not
he was
there yet
understand,
in
but I mean,
August.
the issue,
sorry.
though, the issue is the city is not paying him as its employer, it is paying him as its self-insurer.
Correct.
And when you're making payments to somebody as the self-insurer, isn't that a different animal from making payments to somebody as its employer?
I suppose it is.
So doesn't that mean you lose?
No, because the issue is his entitlement to benefits, I'm sorry, it comes from the employer, So as a self-insurer, the city, he's not entitled to receive any compensation arising out of his public
So
employment.
if the city had chosen to hire, to have a workers' comp insurer handle its workers' comp
Yeah.
and not be self-insured, you would say to the insurer, you don't need to pay these benefits anymore because Mr. Benoit has been suspended by us?
No, I guess our position on that, Your Honor, is that the relevant question is as whether workers' compensation is compensation with meaning of Chapter 268A. And if it is, and it arises out of his employment, he's not entitled to receive it. That's our position.
Well, I understand that, but I mean, my concern is that workers' comp is viewed as monies paid by an insurer or a self-insurer, essentially as a quasi-tort liability, which makes it a different animal from the kind of compensation that Section 25 is intended to cover. And I mean, it seems as if it's only because the city happened to be a self-insurer that it's in this position.
Do you know, if there were a municipality that did not self-insure, maybe there do exist some, I don't know, but let's assume that they did, would you know whether, when suspension happens because of a pending indictment, before the DIA, does the employer ever appear, or is it only the insurer?
You know what, Your Honor, I don't know. We're a self-insurer, so we always appear directly in those claims.
Well, let me ask you this. Let's imagine something different had happened to Mr. Benoit. Let's imagine that the ambulance that he was working on had crashed, and he had a catastrophic injury which resulted in him being paralyzed from the waist down, unable to work for the rest of his life. Is it your view that because he had engaged in misconduct for the city during the course of that employment, that he'd be barred from all workers' comp coverage that he otherwise would have received as a person who was paralyzed during the course of his employment?
Yes, because that compensation arises directly out of his employment. And the word compensation in Section 25 is defined in Section 1 of Chapter 268A with extraordinary breadth. It's defined as any money, anything of value, or any economic benefit. That's what the word
You forgot the key
compensation
phrase,
is.
which is, quote, in return for services rendered.
Right, but
And these monies are not being received in return for services rendered. These monies are being received as a quasi-tort liability as compensation for injuries suffered on the job.
But our position of that, Your Honor, is that the way that language means arising out of the employment or for services rendered was clarified in this court's decision in City of Springfield, which we've cited, and it says, all of that language means in the economic realities of the days is that it's a form of compensation that arises because there is an employment relationship. This is compensation payable to an employee. The benefits under Sections 34 and 35 are particularly titled that, and you only get workers' compensation because there's an employment relationship, and you have to show that you suffered an injury in the course of employment. That's the basis for the compensation. So, but for the employment relationship, there is no compensation here.
But that was the employment relationship at the time of the injury, not thereafter necessarily.
But that's the,
Because oftentimes people who receive workers' compensation no longer remain employed by the same employer.
right, but Mr. Benoit did.
But I know, but I'm just saying as a general matter, in determining whether or not the term compensation applies as you suggest it does. It doesn't mean that it is only for the period of time that the injured employee remains employed.
That's correct, but that suspension statute cuts off any of that compensation.
Only if it's compensation for services rendered.
That's right, and our claim is that it is.
So let's assume you're right about the suspension period. I don't see, how do you, Judge Wilson found that you need to read the statute as applying beyond that. And I'm just, when the statute is about suspension, and it's only about suspension, how do you get to post-suspension?
Because, Your Honor, the statute, Section 25, is not silent about the duration of the suspension or the conditions under which it can be removed that would entitle the employee
To what was held back during the suspension, but it doesn't really talk about what happens thereafter, does it?
So, yeah, so our interpretation of the statute is that what the legislative design here, and there's three provisions that we think support this in Section 25, is first of all is that the suspension itself, the notice of suspension, doesn't just remove the employee from office, it prevents them from receiving any compensation arising out of their employment. Those two things go together, the right to reinstatement and the right to compensation. The next provision in the statute talks about removal, and it says the suspension shall remain in effect unless and until it's removed by the appointing authority. So, which is the city in this case. That's the language of the statute. Once notice is given, the suspension stays in effect until it's removed. It can't be removed by the employee. And then the third and final, the final paragraph of Section 25 says that if the employees, the criminal charges under which the employee has been indicted, any of them result in a finding of guilt or a conviction, as it did in this particular case, then the employee is entitled to have the suspension removed, they're entitled to reinstatement, and they're entitled to the compensation. Our position is under that statutory condition, the converse of that is that if they're convicted, as Mr. Benoit was, they're not entitled to reinstatement, and they're not entitled to receive any compensation.
Could I ask you, I'm just trying to understand the rationale for interpreting the statute to require that no workers' comp benefits be paid during a suspension. I mean, you can see the salary, that makes sense because it's in the nature of punishment. But if somebody is on receiving workers' compensation benefits, I mean, that's something that has happened to them that has nothing to do with the underlying criminal conduct. And I'm just trying to understand what's the rationale for that. I mean, if you got a pension, clearly this worker would not would have trouble collecting that pension, but I'm having trouble understanding why an injured worker would be punished under that statute. Why would we do that?
Well, I guess the underlying rationale for the statute would say, Your Honor, is that the idea is that an employee, and this statute applies in a very specific circumstance where an employee is indicted for criminal misconduct in office. And that the underlying rationale for the statute is that when that happens, those employees should not be entitled to compensation arising out of their public employment to which employees who don't engage in that conduct have engaged. And once the employee is indicted and suspended, then their ability to have reinstatement and to receive any compensation arising out of their public employment is conditioned on the outcome of the criminal proceedings. That's our position. And under the statute, going back to Chapter 268A, Section 1, that compensation clause is extremely broad and clarified by this court's decision in City of Springfield. And the same thing could be said for unemployment benefits or any other form of compensation. Under the ethics statute, any compensation that arises because of the employment relationship, which workers' compensation benefits do, constitute compensation under that act and are subject to the suspension statute.
Does the unemployment, I appreciate that unemployment compensation is covered. Is there any reference to that in the unemployment compensation statute itself, to the fact that if you're a public employee, it's not going to be, because that wouldn't be true of a private employee, right? Or would it?
If the
No, because
question,
Section 25 only applies to public employees,
That's
right?
correct.
So is there any reference in the unemployment compensation statute to this link between Section 25 and unemployment compensation?
not that I'm aware of, Your Honor, no.
Okay.
Okay, thank you.
Thank you.
All right, we'll take our morning break.